I'm Ford Evenson, and this is my presentation on Neer v. Minnesota, 1931. So, before I get into the facts of the case, I'll just explain some background real quick to help with the facts of the case. So, essentially, at this time in America, between the late 1920s and mid 1930s, organized crime was a really big thing in a lot of major cities, and it caused a lot of corruption and mishandling of local governments and cities, especially in cities like Chicago, New York, obviously, and all Philadelphia, but it also affected cities out in the West or Midwest, such as Minneapolis and St. Paul, which is where this takes place in the state of Minnesota. So basically, these two local reporters who worked at the Saturday Press, Jane Neer and Howard Guilford, wanted to publish a paper about certain city officials, their inefficiencies, and connections to organized crime. Now, it's not surprising that these city officials didn't want them to necessarily publish this, considering they wanted to stay in office. So they tried to use a law called the Public Nuisance Law, which prohibited anyone working in press or in a public business to publish anything scandalous or defamatory towards other people. And so they tried to use this law to get a cease and desist order on these reporters and their publisher to keep them from publishing. So Jane Neer and Howard Guilford appealed to the Minnesota Supreme Court, but the Minnesota Supreme Court actually agreed with the city officials under the definition of the law they were using. So, of course, not being happy with this and probably not wanting to get killed by some gangsters, they tried to appeal to the Supreme Court. And so the Supreme Court had the question of whether or not the gag law, aka the Public Nuisance Law, violated the Freedom Press Clause under the First Amendment and also the freedom of speech for these reporters. Now, after reviewing the question, they decided that under the Free Press Clause, with limiting exceptions, the government may not censor nor prohibit the free press from publishing, and said that prior restraint couldn't be used in this case. And going on to the conclusion, they basically said prior restraint or limiting the press can only be used in certain instances, which includes inciting violence, inciting threats, or publishing government secrets that could threaten national security, which is related to another case, New York Times versus United States, 1971, which I'm pretty sure someone else is doing, but I almost made a discussion question. And they also said that in other legal cases, legal action cannot be taken until after the paper is published, such as a defamation lawsuit. And they also argued that under the general application of the law by Minnesota Supreme Court, they were wrong because it did not factor in the specific factors of this case, which was trying to report on, the city officials being involved with organized crime. So for discussion questions, I thought it would be interesting to talk about to what extent do you think the press or people can publish information that can damage a person's reputation or life. And I think this is especially important for public figures or celebrities who are constantly harassed by the paparazzi or press who just have an all-seeing eye in their public lives and they can't really do anything about it. And that brings up the next question: are celebrities or public figures victims of the free press, especially the paparazzi? And what is the difference between defamation and reporting? I feel like all three of these questions go hand in hand, so you can probably all answer them in a single answer, but I'm not sure. And these are my this is my resource. I pretty much only use Oyez. So yeah, thanks everybody. Have a good discussion, I guess. Yeah.